Welcome to this Deep Dive Learner. Today we're tackling a really important area, tracing in equity and trusts law.
That's right. It sounds technical, maybe, but it's absolutely vital.
We're using materials made available by the University of London. Huge thanks to them purely for educational purposes, of course.
Yep. And our aim today is to give you a really solid grasp of this, focusing on the key ideas, the big case names you need to know. Basically, get you ready.
So the core mission, understanding how beneficiaries, the people the trust is for, can follow and identify trust property that's been misappropriated.
Even when it changes form. That's the crucial bit. Money becomes shares, shares become a car.
Yeah,
Hey, how do you follow that value?
exactly. So let's start with the basics. The materials mention three key concepts: following, tracing, and claiming.
Yeah, and getting these clear is step one. You follow the original asset, the actual thing, as it moves from hand to hand.
Okay, following the physical asset.
Then you trace. Tracing isn't about the asset itself, but its value. You trace the value as it gets substituted or mixed.
Ah, okay. So follow the thing, trace the value,
Yeah.
and claiming.
Claiming is the end game. Once you've identified where the value is using tracing, you then make your claim to get it back, either the asset itself or its equivalent value.
This framework, follow, trace, claim, it comes from Smith, right? And Millet LJ adopted it in Boscawen v. Bourgeois.
That's the one. Boscawen v. Bourgeois, a key case we'll come back to. And it's important to realize tracing itself isn't the remedy, it's the process.
Right. It's the detective work you do before you make your claim.
Exactly. And it underpins both proprietary claims, trying to get the actual thing back, and personal claims, like suing the trustee for the loss.
Got it. So foundational stuff. Now, the materials draw a big distinction, tracing in equity versus tracing at common law. Why are there two systems?
Well, historically, they developed separately. Equitable tracing is generally wider and more flexible. Crucially, it's available where there's a fiduciary relationship.
Like between a trustee and beneficiary.
Precisely. Or director and company, solicitor and client. You need that pre-existing relationship of trust and confidence. Key cases here are Re-Diplock, Elajou v. Dollar Land Holdings.
Re-Diplock Elajou. Got it. What about Chase Manhattan v. Israel British Bank? That one seems a bit debated.
It is, yes. There, the court sort of stretched things to find a fiduciary relationship, even for a mistaken payment, allowing tracing in equity. It shows equity's focus on preventing unjust enrichment where there's some sort of duty.
Okay, so equity needs that fiduciary link. What about common law tracing then?
Common law tracing is much more limited. You generally need to be asserting legal title, not just a beneficial interest. Think Taylor v. Plumer, though its exact scope is debated.
And the big practical difference?
Mixing. Common law tracing, generally speaking, hits a brick wall if the property gets mixed with other property, especially money in an active bank account. It needs the asset to remain identifiable.
So, if trust money goes into a bank account with other funds, common law tracing usually stops.
That's the traditional view, yeah. Cases like Lipkin Gorman v. Carpnell and F.C. Jones and Sons v. Jones illustrate this. Although, interestingly, Millet L.J. in F.C. Jones thought maybe the rules should be unified.
But for now, we treat them as separate, and common law tracing struggles with mixtures.
Correct. Common law, no mixing, generally. Equity needs fiduciary link, but can handle mixing. That's the core takeaway.
Right. So let's dive into the equity rules for tracing through mixtures. This is where it gets complex, isn't it? Especially when the trustee mixes trust funds with their own money.
It is, but equity has developed some pretty clear rules or perhaps presumptions to deal with it. The starting point is that even if the money is mixed, equity treats the trust money as still being there.
How does it do that if it's all jumbled up?
Through presumptions. The first big one is from Hallett's estate.
Hallett. Okay, what's the rule?
The presumption is that the wrongdoer, the trustee in this case, spends their own money first from the mixed fund.
Ah, okay. So if there's £1,000 trust money and £500 trustee money mixed, and the trustee spends £500.
Equity presumes they spent their own £500, leaving the £1,000 of trust money intact. It operates in favor of the beneficiary.
That seems helpful for the beneficiary. But are there exceptions?
Yes, there's a crucial counter-presumption or clarification from Otway.
Otway. What happened there?
In Otway, the trustee mixed funds, then bought shares with some money, and later distributed the rest of the money in the account. If you just applied Hallett, you'd say the shares were bought with the trustee's own money first.
Right, which would leave the trust with nothing as the rest was dissipated.
Exactly. But the court said no. The beneficiaries could claim the shares. The principle is that the trustee can't benefit from the order of transactions if it harms the trust. If an asset is bought, the beneficiaries can claim it represents their money, especially if the remaining fund disappears.
So Hallett says they spend their own money first, but Otway says if they buy an asset and dissipate the rest, the trust can claim the asset.
Essentially, yes. It ensures the wrongdoer doesn't profit from the way they mixed and spent the funds. It resolves evidential uncertainty against the wrongdoer.
Okay, Hallett and Otway. What if the account balance just goes up and down after mixing?
That brings us to the lowest intermediate balance rule from James Roscoe Bolton, LTD v. Winder.
Roscoe v. Winder. Lowest intermediate balance. Sounds like what it says on the tin?
Pretty much. The beneficiary's claim against the mixed fund is limited to the lowest balance the account reached after the trust money was paid in and before any subsequent deposits by the trustee from their own funds.
Example time. Trustee mixes £1,000 trust money with £500 of their own. Total £1,500. They spend £1,300, leaving £200. Then they deposit £500 of their own money, bringing it to £700. What can the trust claim?
Only £200. That was the lowest intermediate balance after the trust money went in. The later deposit of £500 isn't presumed to be repaying the trust unless there's clear evidence.
So the trust can't claim more than that £200 low point from the mixed fund itself?
Correct. Affirmed in Bishopsgate Investment Management v. Human. The lowest balance caps the proprietary claim against the fund.
Okay, so for wrongdoers, Hallett, own money first. Otway, claim assets if rest gone. Roscoe v. Winder, lowest intermediate balance limit. Got it. What if the mixing involves innocent parties? Say, trust money is accidentally mixed with another innocent person's money.
Right, the dynamic changes. Equity tries to be fair to both innocent parties. The presumptions against the wrongdoer don't apply.
So no Hallett.
No. The default rule here, traditionally, is from Clayton's case.
Clayton's case. I've heard of that one. First in, first out.
Exactly. FIFO. The first sum of money paid into the account is presumed to be the first sum paid out. It's just a chronological rule of accounting, really.
So if innocent person A's £100 goes in Monday, and innocent trust B's £100 goes in Tuesday, and then £100 is withdrawn Wednesday.
Under FIFO, that £100 withdrawn is presumed to be person A's money.
Simple enough, but can that be unfair?
It absolutely can, especially with complex funds involving many innocent contributors, like investors in a collapsed scheme. Applying FIFO rigidly could mean early investors lose everything while later ones get their money back, just based on timing.
So is there an alternative?
Yes. The courts have recognized FIFO isn't always appropriate. In Barlow Close International v. Vaughan, the Court of Appeal said that where FIFO is impractical or unjust, a pari passu approach can be used.
Pari passu, meaning?
Meaning on an equal footing.
Yeah.
Everyone shares the remaining funds proportionally based on their contribution, regardless of when it went in or out. It's about achieving fairness between the innocent parties.
So FIFO is the default for innocent mixers, but if it's unfair, especially with lots of people, courts might use proportionate sharing, pari passu, like in Barlow Close.
That's a good summary, yes. Flexibility to avoid injustice.
Okay. Now for something that sounds, well, tricky, backwards tracing, what on earth is that?
It's tracing trust money into an asset that was actually acquired before the trust money was received by the wrongdoer.
How can that work? The trust money didn't buy the asset directly.
Typically, it involves paying off a debt incurred to buy the asset. So the wrongdoer buys, say, a car on finance, then uses trust money later to pay off that car loan. Can the beneficiaries trace into the car?
Seems like a stretch. What's the general rule?
The traditional view, seen in cases like Bishopsgate v. Homan again and Serious Fraud Office v. Hotel Portfolio 2, was pretty firmly against it. No direct link between the trust money and the acquisition of the asset.
The timing is wrong. Money came after the asset.
Exactly. But
Right.
there were hints in earlier cases, maybe Adjip, Africa v. Jackson, or Foskett v. McCune, that suggested it wasn't impossible. The big shift came with the Privy Council case, Federal Republic of Brazil v. Durant International Corp.
Durant. Okay, what do they say? This sounds important.
Very important. The Privy Council acknowledged the general rule against backwards tracing, but opened the door a crack. They said it can be allowed where there's a close causal and transactional link.
A close causal and transactional link. What does that mean in practice?
It means you need to show a clear connection between the incurring of the debt for the asset and the use of the trust funds to discharge that specific debt. It suggests a coordinated scheme where the debt was taken on anticipating the arrival of the trust funds to pay it off.
So not just any debt repayment. It has to be linked specifically to acquiring the asset, almost like the whole thing was one plan.
Precisely. Lord Tolson in Durant stressed it shouldn't be used loosely. But where that tight connection exists, the court can look at the substance of the transaction. And this approach has found some support in English cases too, like Shovlin v. Site Civils.
So the general rule is still caution, but Durant allows backwards tracing if you can prove that really strong planned link between the debt for the asset and the trust money paying it off.
Exactly. It's a significant development, but the evidential burden is high.
Right. We've traced now the claiming part. What remedies are available?
Okay, so tracing identifies the target. The claim is how you get it back. Broadly, you have personal claims and proprietary claims.
Personal claims first.
That's a claim against the wrongdoer, or sometimes a knowing recipient personally. It's basically saying, you owe the trust X amount because of your breach. It's useful if the property itself is gone or has dropped massively in value.
So suing the individual for the value lost.
Correct. But often the goal is to get the specific asset back or claim rights over it. That's a proprietary claim.
And there are different types of proprietary claims.
Two main ones based on tracing. You can claim the asset is held on a constructive trust for the beneficiaries.
Meaning they become the equitable owners.
Yes. This is great if the asset has gone up in value. If the trustee used £10 of trust money to buy shares now worth $15K, the beneficiaries want the shares, not just the $10K back.
Makes sense. What's the alternative?
An equitable lien or charge over the asset. This doesn't give ownership, but it gives a security interest.
Like a mortgage.
Sort of, yes. It secures the amount of trust money that went into the asset. The beneficiaries can force the sale of the asset to get their money back.
When would you want a lien instead of a constructive trust?
Two main times. If the asset has gone down in value. If those £10 K shares are now worth 8Ks, you'd rather have a lien securing the £10 K debt than own the 8K shares. Also, if the asset was bought with mixed funds, trust money and wrongdoer's money, a lien over the whole asset securing the trust's contribution is often the appropriate remedy.
Okay, so constructive trust for ownership, good for gains. Equitable lien for security, good for losses or mixed funds. Clear. Now, one more concept. Subrogation. Stepping into someone's shoes.
Exactly right. Subrogation allows one party to take over the rights and remedies of another, like an insurer paying out and then taking over the insured's right to sue the person who caused the accident.
How does that apply here with trusts?
If trust money is wrongly used to pay off someone else's debt, the trust might be able to step into the shoes of the creditor who was paid off.
Why would they want to do that?
Because the original debt might have had security attached. Imagine trust money is used to pay off a mortgage on the trustee's house.
Ah, so the trust could step into the mortgagee's shoes and get the benefit of that mortgage security over the house.
Precisely. This gives the trust a proprietary remedy against the house, which is much better than just a personal claim against the potentially bankrupt trustee. The key case here is Boscawen v. Bourgeois.
We mentioned that earlier, Boscawen v. Bourgeois. Tell us about it quickly.
Sure, simplifying slightly, money from lender B, intended to secure a second charge on a property, was mistakenly used to pay off the existing first mortgage held by lender A. Lender B didn't get their charge.
So their money was used, but they got no security.
Right. The court held lender B was subrogated to lender A's rights. They effectively revived the first mortgage for their benefit, giving them a secured claim against the property because their money had discharged that secured debt.
That's a powerful remedy. So subrogation is crucial when trust money pays off a secured debt. Remember Boscawen v. Bourgeois?
Absolutely. It's a vital tool in the claiming armory after tracing.
This has been fantastic. So, learner, pulling this all together, what are the absolute must-know focus points from the University of London materials for exam success?
Okay, priority number 1, definitions. Nail down following, tracing, and claiming. Be able to explain them and spot them in scenarios like that study task 1 mentioned.
Definitions first. Got it.
Second, the equity versus common law tracing divide. Why is there a difference? What's the fiduciary requirement for equity? What are the limits of common law, especially mixing? Expect questions on this.
Differentiating the two systems. Crucial.
Third, the rules for tracing through mixtures in equity. This is core territory. For wrongdoers, Re-Hallett, Re-Otway, Lowe's Intermediate Balance, Roscoe v. Winder. Know the rule, the case name, and how to apply it.
Case names and application for wrongdoer mixing.
And for innocent parties, FIFO, Clayton's case, has the default, but also the pari passu exception, Barlow close, for fairness. Practice applying these with numbers, work through examples.
Innocent mixing rules, too. FIFO and pari passu.
Fourth, backwards tracing. Understand the general reluctance, but know the Durant case and the close causal and transactional link test inside out. It's a specific, important exception.
The Durant exception for backwards tracing. Key phrase.
Fifth, claims. Distinguish personal claims from proprietary claims. Within proprietary, know the difference between a constructive trust and an equitable lien, and we need to argue for each.
Constructive trust versus lien, know the difference.
And finally, sixth, subrogation. Understand the concept of stepping into shoes, especially regarding secured debts, and remember Boscawen v. Bajwa is the prime example.
Subrogation and Boscawen. Okay. Anything else?
Yes. Really use the learning resources, check the learning outcomes in your guide, use that Am I Ready to Move On checklist, and definitely review the essential readings, especially the key cases we flagged. There's no substitute for reading the judgments.
Great advice. So that's a solid roadmap for studying tracing, based on those University of London materials. It's about following value, applying the right rules, and knowing the claims.
Exactly. Get those building blocks in place, and you'll be well on your way.
So, learner, as you dive deeper into this, here's something to ponder. We live in a world of crypto, instant digital transfers, incredibly complex financial products. How might these traditional principles of tracing, developed largely around bank accounts and physical assets, need to adapt to stay effective and fair in the 21st century?
That's the big question, isn't it? How does equity, which prides itself on flexibility, keep pace? A fascinating thought to take away.
Indeed. And a final reminder that we've been discussing materials provided by the University of London for educational purposes, and this deep dive is purely to support your learning journey.